Hello everybody, it's Zach here from RealEstateLicenseWizard.com. Today we're talking about contracts, specifically what makes a contract valid within the world of real estate. Contracts are required in every real estate transaction, whether commercial or residential, so it's essential you understand contracts not only for your exam, but also for your real estate career. Now there are 4 different requirements to a valid contract, each of which I'm going to cover today to help you understand what makes a contract valid. So without further ado, let's jump right into it. Okay, so to start off, I'm going to briefly show you all 4 requirements, and then I'm going to go into each one in detail. And make sure to stay tuned after, because there are some additional smaller requirements that I'm going to go over as well. Alright, so the 4 main elements or requirements of a real estate contract are: 1. Correct parties involved, meaning the party must be of legal age of 18 or older and deemed legally competent. 2. A legal purpose must exist. The contract must hold a legal purpose. More on that later. 3. Some form of consideration must exist, meaning a clear and specific consideration must be included in the agreement. 4. A mutual consent must exist, meaning the contract must hold mutual consent or be agreed upon by both parties. So let's break this down. Let's talk about that first requirement. So to enter into a contract, all parties must be legally competent. At the time of signing the contract, you must be of legal age and mentally capable. Those are the 2 things: legal age and mentally capable. Now, obviously, there are some exceptions to this rule where a person has authority to sign contracts on someone else's behalf, like maybe a company, a minor, or power of attorney. They have power of attorney and they sign somebody, a contract for somebody else, maybe that's not capable. So obviously there are exceptions to this rule, but primarily, again, they need to be 18 years or older and of sound mind or mentally capable. Next, for that second one, we have to talk about legal purpose. So parties cannot carry out a contract to do anything illegal. For example, they can't have a contract to kill, steal, or do anything illegal. The contract's purpose must comply with the law. An agreement between 2 parties that involves one defrauding the other would be considered void. As for real estate, contracts must be presented in written form and hold legal value. In order for that to obtain that legal purpose, those 2 things need to happen. Again, it needs to be written, which you guys should know. We've talked about before in this channel. It needs to be in written form, and then obviously there needs to be legal value. Next, on the topic of value, let's talk about consideration, the third requirement. So anything of legal worth offered and exchanged in the agreement is referred to as consideration. Consideration is a term that is commonly linked to money, but it can refer to anything of value. The goal of requiring consideration is to establish that the contracting parties have reached an agreement. As long as it is present, it makes no difference with the size, number, nature, or amount of what is being exchanged. It's just important to note, obviously, consideration must be specified and written in the contract to add to its validity. Now, a contract cannot be legally enforced if there is no consideration. All parties must offer some form of consideration for there to be legal acceptance. And lastly, that 4th one is mutual consent. So mutual consent requires that the contracting parties have willingly and knowingly consented to the contract's conditions. Any party involved in the contract cannot be subject to fraud, misrepresentation, error, or, under duress, things like that. The character of the offer must be explicit, and the property must be accurately defined to identify the subject matter, and the price must be exact. Ultimately, both parties must agree to these terms mutually in an official offer and acceptance, which you guys should know what that is. If not, I can go in detail on that in another video. So now those 4 are the main requirements, but there are some additional contract terms and elements that we need to cover, not only for, again, the real estate exam, but your career. So remember, like in all things in the United States, things differ from state to state. While most elements of a valid real estate contract are the same from state to state, there are some differences depending on your state and circumstance. Remember, a transaction in real estate is based on the principles of common law, meaning ultimately it should apply to both federal and state mandated laws. Now, in most cases, the purchase price of the subject property must be specified in the agreement, which a little bit we talked about earlier. But for a contract to be enforceable, it has to include that agreed upon sales price. Finally, the subject property must be identified in the contract. And I know I touched a little bit about that earlier, but it's really important to distinguish because obviously in a real estate contract, it's more specified than just a regular contract. So the agreement must be in writing, which we talked about, and include at least the property's physical address to clearly identify the subject properly. Now, obviously, a legal description of the property is desired. However, it's not necessarily needed. But it's a good idea to do that. And it's a good idea to obviously print the date on which each participant signs the contract, as well as an expiration date. So another question I get asked a lot about on the topics of valid contracts is, at what point is a real estate contract valid? And it's a bit of a tough question to answer, and you'll see soon why. Basically, a real estate contract is valid when all requirements are met and the documents are signed. So the timing or point of validity depends on the circumstances as well as the contract. Now, there are various types of contracts in real estate: unilateral, bilateral, implied. The different types of contracts usually determine at what point the real estate contract becomes valid. Generally speaking, though, in most cases, a real estate contract becomes legally binding the moment it's signed by the buyer and seller. Of course, we have to discuss the not so simple cases. Those instances involve contingencies. Now, a contingent property means an offer for the property has been accepted, but there is a condition or contingency that is written into the contract, and it must be met before the sale can go through. Now, in order for the contract to be legally binding, the contingency obviously must be met. So in these cases, the point the contract is valid is different than a regular contract, because again, all conditions must be met before the contract is valid. So again, it's not as simple as once it's signed, it's done, it's good to go. Something needs to occur. A condition has to be met. And obviously, again, that's going to depend on that contract and the circumstance and what type of contract it is. So what do you need to know for the exam? Let's put this all together. So come exam day, you need to be familiar with the 4 elements that make a contract valid in real estate. We covered those. You also need to understand at which point a contract becomes valid. We covered those as well. And obviously we know that that depends on the situation and circumstance. If you can put all that stuff together, learn all those things, make sure you're familiar with that, and also the different types of contracts, which don't worry, we're going to be covering soon, you'll be set come exam day. So yeah, this was Zach from RealEstateLicenseWizard.com. Have an amazing day. Until next time. See you guys.